Right on. Peace and love to all my followers, to all my subscribers, I should say, not followers, because I'm not a messiah or anything. So, peace and love to all my subscribers if you can hear me. I hope that you can hear me. So, this video is dedicated to one particular troll, Brad Double D. He calls himself radd, but I'm going to call him Brad with 2 D's. Because you would just think that someone who is as ignorant as this guy is would know that in order to carry a name such as radd, radd meaning radical, that you would have to actually earn that name. Now, if you've earned that name through ignorance, then you're a lost cause. So radd, like I said, I'm gonna be on you on this video because, as you can see on my screen, radd, Hendricks versus Maryland, the case you swear up and down gives the state the right to put license and registrations on all vehicles. And then you tried to argue me down, telling me that this case had nothing to do with the fees and all that I misinterpreted the case. Well, no, as I told you in the DMs, no, I didn't misinterpret the case. You misinterpreted the case. You misinterpreted this case so much to the point that you failed to even understand it in its entirety. 1. Motor vehicle, commercial term. You said that I can't provide you with one case law that defines what a motor vehicle is. Well, guess what? Unfortunately, it's not going to be on the screen, but I am going to read to you right here. These are Supreme Court decisions that defines what a motor vehicle is. But first, we're going to address this issue about Hendricks versus Maryland. And in the event that you're wondering, yes, radd, I actually do. See, unlike all the rest of you people, the people that you argue with, I actually do go to the law library and actually do copy the cases straight out the books. I don't get online cases. I don't mess with online cases. Every case that I deal with, every case that I present here on my channel comes straight from the law books. So we will get to the Supreme Court cases and the definitions, but before we do all of that, I'm going to go and show you some things that you obviously don't know. Starting off with Hendricks versus Maryland. Okay, as you know, it's a 1915 case. Case means nothing here nor there anymore because this case does not have any significant power or authority. The only authority it has is the fees that was imposed upon a license and a registration. Now we're going to go here to the first part of the case, which I don't understand how you couldn't understand this, because it actually addresses one of the issues that you brought forth towards me right at the very beginning of the case. Only those whose rights are directly affected can properly question the constitutionality of a state statute and invoke the jurisdiction of this court in respect thereto. Meaning, if you ain't from that area, you can't raise a claim talking about discrimination, that the fees are discriminative, because that's what Mr. Hendricks is arguing. He's not arguing about the fact that a license and registration are required to operate his motor vehicle, commercial term. He's not arguing that. He's arguing the fact that there's fees attached to that license and registration. That's what he's arguing. So let's continue to go here, because I want to make sure that you know and understand this. Where a state statute provides as a prerequisite to the use of the highways of a state without cost, did you see that? Without cost by residents of other states, compliance with the highway laws of their respective states, one who does not show such compliance cannot set up a claim for discrimination. In this particular, meaning he ain't from there, he can't raise a claim saying that it's discriminative, okay? And not decided whether the motor vehicle law of Maryland is so discriminates against residents of the District of Columbia as to be unconstitutional, denial of equal protection of the laws in the respect that this court will assume in the absence of a definite and authoritative ruling of the court of such a state to the contrary, that when a statute shall be construed by the highest court, discrimination against the residents of a particular state and or territory will be denied. In other words, what it says up here, radd, it says up here that since no court has ever ruled in regards to this, meaning there is no case law that supports or substantiates that claim, there will be no claim. In other words, what the court just told you right there is they can't even dispute or argue that claim based on the fact that, one, they don't hold jurisdiction over it, two, there's no case law in reference to that. That's what that means. That's not my opinion, that's what that says. Okay? And I'm not even going to read through this whole case because I got other things that I want to do for you, and I just want to make sure that this is just in a little short video to you. So when you come here, the movement of motor vehicles over highways being attended by constant and serious dangers to the public and also being abnormally destructive to the highways is a proper subject of police regulation by a state. In the absence of national legislation, did you hear what that said? In the absence of national legislation covering the subject, a state may prescribe uniform regulations necessary for safety and order in respect to operation of motor vehicles on its highways, including those moving in what? Interstate commerce. Reasonable graduated license fee. Whoops, radd, seems like you don't know how to read. Clearly states it right there on the first page of the case. License fee on motor vehicles when imposed on those engaged in what? Interstate commerce does not constitute a direct and material burden on such commerce. Whoops. Commerce. Again, I told you this case was in reference to commerce. Well, there it is, clearly stated right there 3 times on the very first page as to what the case is in regards to. Commerce. Okay? And render the act imposing such a fee void under the Commerce Clause of the Federal Constitution. A state may require registration. Did you see that? It doesn't say that the state mandatory. It says a state may require, meaning their own discretion, under their own discretion, registration of motor vehicles, and a reasonable license fee is not, what does it say right here? Hang on, let me find it again. I lost it. Oh, there it is. And a reasonable license fee is not unconstitutional, as denial of equal protection of the laws, because graduated according to the horsepower of the engine, such a classification is reasonable. Damn. Look here. Let's go down here. The reasonableness of the state's action is always subject to inquiry insofar as it affects interstate commerce. And in that regard, it is likewise subordinate to the will of Congress, a state which at its own expense furnishes special facilities for the use of those engaged in what? Interstate and intrastate commerce, may exact compensation therefore, And if the charges are reasonable, and uniform, they constitute no burden on interstate commerce. Hence the reason why the states never use this case against us, because we're not challenging the fees that are attached to a license and registration. You idiots, you morons, for all of you out there who constantly try to throw Hendricks versus Maryland up in our faces, talking about Hendricks versus Maryland ruled this, that, and the other. No, it did not. Nowhere on its face does it say anything about a license and registration being mandatory. The case is talking about the discriminatory relation that fees being attached to a license and registration would draw. However, in its writing, the justice writing here, he clearly made it. He established and made it very clear that if you are not from that area, not a resident of that area of Maryland, you cannot impose or present a claim of discrimination, okay, if you're just passing through. You cannot do it. You don't have jurisdiction. You can't even gain the court's jurisdiction by not being a non-resident. By being a non-resident, you impose no jurisdiction. Okay? That's what this case is about. It's about a statute imposing a fee to a license and registration. Okay? And Mr. Hendricks claimed that the fee was discriminative because it classified a certain class of motor vehicles. Does it say that in here? Yes, it does. It actually does say that in here. It says it right here, as a matter of fact. The law is unconstitutional in that the registration fees provided for and graded according to different scales of payments have no relation to the necessary expenses of identification or control of motor vehicles, and constitutes arbitrary, unequal, unfair, and class legislation, and does not ensure to the citizens of the United States equal protection of the laws. The tax imposed is not laid as compensation for the use of the roads. Now, and what he says, what his claim was, the act is an illegal attempt to regulate interstate commerce. At no given time does that fee have any dealings with interstate commerce. That fee does not stop the fact. If you want to deal in interstate commerce, you are going to pay that fee. Period. End of story. Interstate commerce. Let's look at the word commerce. Period. Commerce. To do business or trade. Internationally, nationally, domestically, wherever business and trade goes on. You can look that up in a common dictionary. You can look it up in the legal dictionary. The definitions are the same. They're all the same. None of them changed. The word commerce tells you what this case is all about. The term motor vehicle tells you that they are talking about commercialized vehicles. Regardless as to whether or not Mr. Hendricks was driving in his personal automobile, if you read part of this case in here, it actually says right here, in the absence of any light on the question from the record, the court cannot pass on the question as to whether the amount of the license prescribed by the act in question bears any relation to the necessary expenses of identification or control of motor vehicles operated in the state of Maryland. But that's not what I was getting at, but that is a fact that you do need to know. The fact that the law operates only on motor vehicles does not create an unreasonable classification of vehicles using the roads, and is not an unlawful discrimination against a particular class. There's that part that I was just telling you about. So, the 14th Amendment was never intended to abridge the police power of the state if the act in question is properly within the police power of the state. This court will not inquiry further. Okay? Plaintiff in error was not engaged in interstate commerce. Yeah. But that was never addressed. So therefore, you understand, it was never ruled on. He knew he wasn't engaged in interstate commerce. He was just traveling. But he never addressed that issue, so therefore they can't address that issue. You don't bring up an issue, the court's not going to bring it up for you. That's not how the courts work, radd. In order to say that a person or thing is moving in interstate commerce, the movement must be continuous. The right of the citizen to go to and from the states of the Union is not based upon the theory that by so doing they are engaged in interstate commerce. It is expressly put upon another ground in Crandall versus Nevada. The act is not in conflict with Commerce Clause, although commerce between a state and the District of Columbia is interstate commerce. Did you hear that? The states or their agents, municipal or private, may make and collect a charge for facilities rendered, and such a charge is not a tax or a burden on or interference with interstate commerce. Although it may incidentally, they just told you an answer right there, so you have to go in and do your homework and realize that somewhere in that there could be a violation. Incidentally affect interstate commerce in return for the additional facilities and improved conveniences provided. States are permitted to charge and collect reasonable compensation. Imagine that. Imagine that. So, there you have it. radd. The act constitutes no unlawful discrimination against residents of the District of Columbia. It is a proper exercise of the state of its police power. The alleged discrimination cannot be complained of under the Fourth Amendment. Under the 14th Amendment, the act could only be invalid under the Privileges and Immunities Clause or the Equal Protection of the Laws Clause. These clauses go no further than to prohibit the state from imposing greater restrictions or burdens on citizens of other states or the United States than it does on its own citizens. The act conforms to this. Ward versus Maryland, slaughterhouse cases, Blake versus McClung. So what I want to get to is the very end. See, even in this case, Mr. Justice McReynolds delivered the opinion of the court. Plaintiff in error was tried before a Justice of the Peace, Prince George's County, Maryland, upon a charge of violating the motor vehicle law. A written motion to quash the warrant because of conflict between the statute of the Constitution of the United States was denied. He was found guilty and fined. Thereupon, on appeal, an appeal was taken to the circuit court, the highest in the state having jurisdiction, where the cause stood for trial de novo upon the original papers. It was there submitted for determination by the court upon an agreed statement of facts grievously verbose, but in substance as follows. The cause was originally brought in July 27, 1910 before a Justice of the Peace for Prince George County by the state against John T. Hendricks for violating Section 133 of the Motor Vehicle Law. Motor Vehicle, Commercial. July 1st, 1910. He was a citizen of the United States, resident and concomitant in the District of Columbia. On that day, he left his office in Washington in his own automobile and drove it into Prince George County, and while temporarily there was arrested on the charge of operating it upon the highways without having procured a certificate of registration required by Section 133 of the Motor Vehicle Law. He was brought before a justice of the peace and fined $15 after having been found guilty of the charge set out in the warrant duly issued. A motion to quash having been denied, whereupon he filed his appeal at the time and placed aforesaid he had not procured the certificate of registration for his automobile required by Section 133. Upon the foregoing, the court shall determine the questions and differences between the parties and render judgment according to their rights in law may appear in the same manner as if the facts aforesaid were proven upon the trial. Either party may appeal. The Maryland legislature, by an act effective July 1st, 1910, 207 Laws 1910, 168 at page 177, prescribed a comprehensive scheme. Listen now, radd. Prescribed a comprehensive scheme for licensing and regulating motor vehicles. The following summary sufficiently indicates its provisions. The governor shall appoint a commissioner of the motor vehicles with power to designate assistants who shall secure enforcement of the statute. Before any motor vehicle is operated upon the highways, the owner shall make a statement to the commissioner and procure a certificate of registration. Therefore it shall bear a numbered plate. The certificate and plate shall be evidence of authority for operating the machine during the current year at Section 133. Registration fees are fixed according to horsepower, $6 when 20 or less, $12 from 20 to 40, $18 when it exceeds 40 at Section 136. Here's the part where you failed to understand, radd. No person shall drive a motor vehicle upon the highway until he has obtained at a cost of $2, did you hear that? An operator's license, subject to revocation for cause. Any owner or operator of an automobile, non-resident of Maryland, who has complied with the laws of the state in which he resides, requiring the registration of motor vehicles or licensing of operators thereof, etc., may, under specified conditions, obtain a distinguishing tag and permission to operate such machine over the highways for not exceeding 2 periods of 7 consecutive days in a calendar year without paying the ordinary fees for registration and operator's license. Section 140. But residents of the District of Columbia are not included among those to whom this privilege is granted. Very simply put, and not my opinion, radd. What that says right there is anyone outside of the District of Columbia is required to register a motor vehicle. Anyone inside of the District of Columbia, not required, as it says right there in plain English, elementary, right there. But residents of the District of Columbia are not included among those to whom this privilege is granted. The other sections relate to speed rules of the road, accidents, signals, penalties, arrests, trials, fines, etc. All money collected under the provisions of the Act go to the Commissioner, and except so much as is necessary for salaries and expenses must be paid into the state treasury to be used in construction, maintaining, and or repairing of the streets of Baltimore and roads built or aided by a county or the state itself. Section 140 is copied into the margin. So there you go. So here you go. Here's what else the justice had to say. Plaintiff in error maintains that the act is void because it discriminates against residents of the District of Columbia, attempts to regulate interstate commerce, violates the rights of citizens of the United States to pass into and through the states, exact a tax for revenue, not mere compensation for the use of facilities, according to arbitrary classifications and thereby deprives citizens of the United States of the equal protection of the laws. If the statute is otherwise valid, the alleged discrimination against residents of the District of Columbia is not adequate grounds for us now to declare it altogether bad. At most, they are entitled to equality of treatment, and in the absence of some definite and authoritative ruling by the courts of the state, we will not assume that upon proper showing this will be denied. The record fails to disclose that Hendrick had complied with the laws in force within the District of Columbia in respect to registering motor vehicles and licensing operators, or that he applied to the Maryland Commissioner for an identifying tag or market prerequisites to a limited use of the highways without cost by residents of other states under the plain terms of Section 140. He cannot therefore set up a claim of discrimination in this particular. Only those whose rights are directly affected can properly question the constitutionality of a state statute and invoke our jurisdiction in respect thereto. Meaning, they didn't even address his issue. I'm not even going to go into reading all that because you already know. I've already showed you. The license registration doesn't even apply to the people in the District of Columbia. It even says so back then in this time in 1910. It didn't even apply to the people directly in the District of Columbia. So there's that. So there you go. This is all about discrimination and the fees attached to the license and registration. Has nothing to do with saying that a license and registration is mandatory. That's never been said. So, with that being said, we now move on to what you said that I could never do. So, what you said I could never do is provide one case law, a case law that classifies and or shows that a motor vehicle is commercial. Well, if you would have looked at my document that I provided on one of my videos, I made a document. As a matter of fact, I have that document right here. Notice of liability, truth, and facts. And this right here is just conjoined of statutes. Okay? I did a video on this, B-Rad, you commented on it. Well, I'm getting ready to show you something. That federal statute, that federal definition of motor vehicle is actually used in several federal court cases, which is all that matters. And that's what you fail to understand. State statutes can't come in conflict. State law, state policy, state definitions, they cannot come in conflict with anything federal, period. Despite your thoughts, despite what you think, despite what you've been told, if you read the Commerce Clause and the Preemption Act set forth in that of the Constitution, you would know this. And you would know and understand that if a state enacts a law, definition, policy, rule, regulation, statute that conflicts with any part of the federal laws, rules, statutes, policies, definitions, etc., etc., federal law prevails. So, United States Supreme Court, there can be no question of the right of automobile owners to occupy and use the public streets or cities or highways in the rural districts. Lemmenbob versus Crandall, 126 Northwest, 69, 110 Minnesota, 454, 456. I'm going to take you back up one. The automobile may use with safety to other users of the highway. In its proper use upon the highways, there is an equal right with the users of other vehicles. Properly upon the highways, the law recognizes such right and use upon general principles. Brinkman versus Pakolike, 84 Northeast, 762, 764, 41, Indiana. These are all federal cases from all the states all around the United States of America. Here you go. The right to make use of an automobile as a vehicle of travel along the highways of the state is no longer an open question. Whoops. The owners thereof have the same rights in the roads and streets as the drivers of horses or those riding bicycles traveling in some other vehicle. Meaning, other vehicle. Motor vehicle. Commercial. House versus Kramer, 112 Northwest 3, 134 Iowa, 374. Farnsworth versus Tampa Electric Company, 57 South, 223, 233, 337, 62 Florida. Did you see that? They went all the way from Iowa all the way down to Florida. These laws are all around the United States, radd, and I don't understand how you don't know about them. You claim that you're whatever you say you are. You're a troll, is what you are. You don't know the law. You sit there and try to argue with me. You can't beat me when it comes to this. So I'm getting ready to show you something. As we all know, 1833 of the U.S. Code, 18 U.S. Code 33 at definition 6 says that it gives you the definition of what a motor vehicle is. Well, here's a federal case that's actually using that definition in it. Imagine that. The word automobile. Yep, let's go there first. The word automobile, Supreme Court case, by the way, connotes a pleasure vehicle designed for the transport. Oh, shit. Sorry about that. Video blanked out. Designed for the pleasure. Shit. The word automobile connotes a pleasure vehicle designed for the transportation of persons on highways. American Mutual Liability Insurance Company versus Chaput. 60A 2D 118 120. Motor Vehicle 18 U.S.C. Part 1 Chapter 2 Section 31 Definitions at 6. Motor vehicle. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in relation to any business or undertaking intended for profit. A motor vehicle or automobile for hire is a motor vehicle. Did you hear that? They even told you the classification of how an automobile becomes a motor vehicle. Any business or other undertaking intended for profit. A motor vehicle or automobile for hire is a motor vehicle other than an automobile stage used for the transportation of persons for which remuneration, which means money, is received. International Motor Transit Company versus Seattle. 251, page 120. The term motor vehicle is different and broader than the word automobile. City of Dayton versus DeBrossi, 23 Northeast 2D. Thus, self-driven vehicles are classified according. There you go. Thus, self-driven vehicles are classified according to the use to which they are put, rather than according to the means by which they are propelled. Ex parte Hofford, 148 Northwest 20. And if you go back up to the case law that I just read you about from Transit Company versus Seattle, the classification, there you go. It just classified it and told you what a motor vehicle is. A motor vehicle is a vehicle used for commercial purposes. Oops. So, we're going to go down here. People versus Nothius, 148 Colorado 210, no state government entity has the power to allow or deny passage on the highways, byways, or waterways, transporting its vehicles and personal property for either recreation or business, but by being subject only to local regulations, safety, caution, traffic lights, speed limits, etc. Travel is not a privilege requiring licensing, vehicle registration, or forced insurances. Also see Chicago Coach Company versus City of Chicago, 337 Illinois. My. There's two cases mentioning that. What the hell? The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and the individual cannot be rightfully deprived. Whoops. Well, B-Rad, looks like you have no argument, bud. Okay, so let's do this. Escobedo versus State, 35 C2D 870 in 8 Cal Jurisprudence 3D, page 27. Right. A legal right, a constitutional right, means a right protected by the law, by the Constitution, but, let's see. Law by the Constitution, but government does not create the idea of right or original rights. It acknowledges them. Did you hear that? State cannot give you rights. It acknowledges the rights that's already been established. When you apply for a license, you're not given a right, you're given a privilege. State can't give you rights. They can only secure, violate established rights. That's all they can do. So for all you police out there who believe that when you get a license it's your right to operate, no, that's not a right. State can't give me a right. Government can't give me a right. That's never, no. Doesn't work like that. It is not a right to drive. Not that I would ever drive a motor vehicle, because I used to. I used to drive 18-wheelers. Go over there on my Facebook page and you'll see. Go on my Instagram, you'll see me and my trucks. I done it. Been there, done that. Under the contract of FMCSA. A license is a contract, people. I don't care what the police tell you. I don't care what a judge tells you. I don't care what anyone, God dang it. I don't care what anyone of any government tells you. A license is a contract. You take a lease and a license. You put them side by side. Okay? You sign a lease. You agree to what? The terms and conditions of that lease. You sign a license. You agree to what? The terms and conditions of that license. You violate that lease. Right? You violate that lease. Your lease gets suspended, terminated. Violate your license gets suspended or terminated or fined or jailed. Imagine that. Same. It's all the same going down the board. Wait a minute. When your lease expires, you do what? You renew it. When a license expires, you do what? You renew it. Whoops. Now, how can you sit there and honestly say that a license is not a contract? It is. And this also goes to say this, that all those statutes that fall under the requirement of having a license, if you have a license, yes, all those statutes apply because you are under their contract. Individuals who do not have a license and not under that, those statutes do not apply because you cannot hold someone to statutes that are related to a contract that he is not a party to. All men are independent of all laws where contracts are concerned. Then he did not consent to. Okay? I did not consent to having a license. Therefore, your rules of license don't apply. They never have. But for some reason, you have these idiot judges, idiot police officers, and lawyers who believe that they do. How? How do they apply? Show me how they apply to me. I'm not under that contract. You don't have jurisdiction over me. Imagine that. But anyway, yeah, you don't have jurisdiction over me because I don't have a contract with you. So how can you sit there and honestly say that those statutes apply to me? They don't apply to me. I'm not going to take my automobile and go down there and give it right back to the state by registering it, especially if I bought it and paid for it straight out of pocket. Now it becomes a state security interest. Hence the reason why when the police pull you over, they run your tags and then they impound your car. Okay? But for those of you who be watching YouTube and thinking that when these police be impounding these people's cars, that was the end of the case and that the police did the right deal, what you fail to understand is you didn't do a follow-up. Every single one of those cops who's impounded a private individual's cars were sued. And they won. Every single one. You know why I know? Because a lot of those people in those videos, I know. I've come across them from one time or another. We've spoke one time or another. And they brought these issues up. In fact, I actually have a gentleman who I counseled who just recently went to court for no registration on his motorcycle. And he won. Based on the information that I gave him. Robert Barr. His documents are on my page. Whoops. Proving that if you're not registered and you're not in their jurisdiction, they don't hold jurisdiction over you. So radd. And this case just happened. He was just ruled not guilty and dismissed 3 weeks ago. Brand new case. 3 weeks old. Yeah. That's right. Facts are on my page. Go to my community page and you'll see it. Yeah, his documents, everything right there. And if you go down there and look in my shorts, video shorts, you'll see a video that I posted back in 2022, dismissed in the best interest of justice. So radd, you don't know what you're talking about. You never did know what you're talking about. Everything that you can sit there and say that sovereigns talk about are nonsense. No, what you're talking about is nonsense. No government has the authority to assert its power over any free man. No government has the authority to assert its power over a natural man where it is artificial. The government is artificial. It's made up. Supreme Court's made rulings on that. It is an entity, a figment of the imagination. Okay, radd? Just in the case that you want to know that, because you're obviously a cop. Because your page, I went over to your page and there's nothing there. And how you got so many followers on a page where there's nothing there is beyond me. They must be your ghost buddies from your precinct. Because all of y'all believe that y'all know the law. You don't know the law. You've just been educated with the law. I just gave you a full education on this case right here, Hendricks versus Maryland. Nowhere in there does it say that license and registration is mandatory. It talks about the fees being discriminative through the statute of which constitutes a motor vehicle, which is commercial, which I just read you the definition, and case law citing that definition that the courts handed down, saying that this is what constitutes a motor vehicle. Now, what I'm going to do for you too, radd, is I'm going to take you over here to this, because I want you to see this. I want you to see and understand this right here. I want you to know and understand this. Whoops. Go ahead. That's wrong. Let's get out of that. I gotta go here. Let's go here like this. There we go. Ah, crap. So my internet dropped for some reason. I don't know why, but anyway, I was going to take you into the definition, the 18 U.S.C. 31 definitions U.S. Code. but for some reason it won't let me. So with that being said, I'm going to cut this video short, and we'll catch you on the flip script, because you can take your ignorant ass over there to that federal definition, 18 U.S. Code 31 at 6, and look at the definition of motor vehicle. It classifies it. It specifies exactly what it is. Then you can take yourself on over there to 15 U.S. Code 1231 and look at the definition of an automobile, and read the definition of automobile, and then go right down right below it and read the definition of a new automobile. The legal terminology of a car before it is sold into commerce is a automobile. Says it right there in its own writing. Have a good one, B-Rad. Hope you got educated. Don't be so ignorant, man. Ignorance is bliss. With all the information and technology that's out there today, ignorance is a choice.